Welcome to this explainer. You know, being accused of a crime is arguably one of the most terrifying, stressful experiences a person can face. Almost overnight, the entire weight of the state's power, the police, prosecutors, this massive legal machinery is pointed directly at you. But a true justice system isn't just a conviction factory, right? It's actually this intricate, carefully constructed maze of safeguards. So today we're going to dive deep into the 25 stages of the Indian criminal justice system under the newly implemented BNSS of 2023. And we're not just looking at a dry flowchart here. We're examining this through a very specific lens, legal protections. We're going to see exactly how the system actively attempts to shield a suspect's fundamental liberty at every single step of this journey.
Put yourself in the shoes of the accused for a second. It's a genuinely frightening thought. But as we map out this process, you'll see exactly how the law builds in these strict, unavoidable checkpoints to protect your fundamental rights. Think of it like a high-stakes tightrope walk. On one side, the state absolutely has to investigate and catch criminals to keep us all safe. But on the other side, there is this absolute non-negotiable necessity to prevent false imprisonment and protect an innocent person's rights. Grasping how the law walks this delicate tightrope is totally essential if we want to understand how justice actually functions in the real world.
Okay, let's quickly map out our agenda for today. We'll be covering 1. The investigation begins. 2. Custody, rights and bail. 3. Pre-trial checks and balances. 4. Defending against the charges. And finally, 5. The verdict and appeals.
All right, jumping right into part 1, the investigation begins.
So the process formally kicks off with an FIR, or First Information Report. But the law actually provides a really vital first filter here, which is a preliminary inquiry. It might surprise you, but the police don't always have to launch a full-blown, incredibly intrusive investigation the absolute second someone makes an allegation. In certain cases, especially where an accusation feels frivolous or may be motivated by a personal grudge, the police are allowed to conduct a limited preliminary inquiry first. And this is a massive gatekeeping mechanism. It actively stops the state's heavy investigative machinery from being weaponized against someone over a completely baseless complaint.
Now, if a full investigation does begin, the police do not just get a blank check. They are bound by incredibly strict protocols. Yes, they collect evidence, record statements, seize articles, and get expert opinions, but they have to strictly follow the rules of evidence gathering. They can't just operate on hunches. And more importantly, if they go through this whole exhaustive process and find the evidence is genuinely lacking, they are legally obligated to file a closure report. They can't just push a flimsy case forward to save face. This closure report acts as a primary legal shield, stopping false charges cold before they ever get near a courtroom.
Moving on to Section 2. Custody, rights, and bail.
Now, what if an arrest actually happens? Well, the law drops a massive, non-negotiable protection rule right here, and it revolves entirely around one highly specific number: 24. That's 24 hours. Under the Section 58 mandate, every single arrested person must be produced before the nearest magistrate within 24 hours, and that completely excludes the time it takes to travel there. I really want to emphasize how critical this checkpoint is, because without this rule, you could theoretically be held indefinitely, just blocked in a room without anyone outside knowing if you're okay. But the law says absolutely not. Within one single day, a totally neutral judicial authority, the magistrate, has to step in, look at you, look at the police records, and make sure your arrest is legally justified and your rights aren't being trampled.
So you're standing in front of that magistrate, and they have a crucial call to make regarding your custody. They have to choose between police custody, where you stay with the investigating officers for interrogation, and judicial custody, where you're placed in a jail monitored directly by the court. The law heavily regulates police custody because, historically, there are inherent risks of coercion there. Judicial custody, on the other hand, puts this thick, deliberate layer of separation between you and the investigators. It reinforces your physical safety right when you are at your most vulnerable.
But even while you're in custody, the legal framework gives you multiple avenues to reclaim your liberty through bail. You've got regular bail, obviously. You also have anticipatory bail, which is this incredible proactive protection where you can seek bail before an arrest even happens if you know false charges are coming. But here's a really fascinating one: default bail. If the police drag their feet and fail to file their charge sheet within a strict statutory time limit, you are entitled to be released, practically regardless of the crime. It essentially forces the state to do its job efficiently and stops suspects from just languishing in jail for years during endless investigations.
All right, Section 3, Pre-trial checks and balances.
Let's assume the police believe they have solid evidence, so they file a charge sheet. The magistrate then takes cognizance, which just means they officially apply their judicial mind to see if a prima facie case exists. But here is where the balance of power shifts in a big way. The law dictates that you, the accused, must be supplied with copies of everything: the FIR, the charge sheet, all the witness statements, expert reports, electronic records, everything. The state cannot ambush you. You have an undeniable right to see every single piece of paper they plan to use against you so you can actually build a real defense.
Which brings us to a huge question. What happens if you, your lawyer, and the magistrate all look at these documents and it becomes blindingly obvious that there's just no real substantial case against you? Does the system just mechanically force you into a grueling, years-long trial anyway?
The answer is a resounding no.
Thanks to the discharge provisions, the law allows for an immediate out. If the court determines there are no sufficient grounds to proceed based on that initial evidence, you are discharged before the trial even gets off the ground. This is an absolutely massive legal shield. Trials are financially devastating, they're emotionally draining, and they carry a huge social stigma. This provision is the justice system's way of cutting the cord early, saving an innocent person from years of trauma over a baseless prosecution.
Next up, Section 4, defending against the charges.
Now, if the magistrate decides there is enough evidence, charges are officially framed. You plead not guilty, and boom, we enter the trial itself. And a trial is a fiercely balanced arena. Step 1 is the prosecution evidence, where they have to prove their case beyond a reasonable doubt while your lawyers aggressively cross-examine them. Then comes Step 2, a very specific, protected moment just for you. And finally, Step 3, where you get to present your own defense evidence, calling your own witnesses and experts to tear down the state's narrative.
I actually want to pause on Step 2 for a second because it's a vital yet totally misunderstood legal right, the statement of the accused. Here, the judge directly asks you to explain the incriminating circumstances stacked against you. You aren't just a silent participant hiding behind a lawyer here. This is your moment to speak human to human with the judge. It ensures your personal voice is heard, letting you clear up misunderstandings or just explain your side of the story without the insane pressure of a hostile cross-examination from a prosecutor.
The trial then wraps up with final arguments. This is the ultimate showdown. It's the culmination of your defense, where your team exposes the legal loopholes in the prosecution's story, tears down their evidence, and fiercely reminds the court of the extremely high burden of proof needed to convict. It is the definitive, final argument before the judge retreats to decide your fate.
Finally, Section 5, the verdict and appeals.
So we've reached the end of the line. The court delivers its judgment, acquittal or conviction. Let's say it's a conviction. Even here, the system's protections kick in. The judge doesn't just bang a gavel and throw you in a cell for 10 years. There is a dedicated, entirely separate hearing specifically for sentencing. The court has to hear you on the question of the sentence. This lets you bring up mitigating factors, your age, your background, family dependencies, or lack of criminal history. It makes sure the punishment actually brings a level of humanity to the process and is proportional, not just mechanical. And of course, this brings us to the ultimate safety net built into the system, the absolute right to seek a second or even third opinion. The law humbly acknowledges a core truth. Judges are human, and trial courts make mistakes. So we have robust rights to appeal to higher courts or to invoke revisional jurisdiction. This exhaustive safety net ensures that one single mistaken verdict doesn't have to irreversibly ruin your life. Which brings us to the literal end of the road, the execution of the sentence. Whether it's jail time, a fine, compensation, or probation, the actual execution generally only happens after the judgment becomes truly final, meaning after all those avenues for appeal have been exhausted. Only after all 25 stages and these incredibly exhaustive, overlapping legal protections have run their entire course does the state finally execute its penalty.
We've seen the incredible depth of the safeguards built into the system, from that 24-hour magistrate check to the pretrial discharge, all the way to the multiple layers of appeals. The law is deeply concerned with protecting the suspect, but it leaves us with this final provocative thought. Does this rigorous, intricate 25-step legal framework perfectly guard our freedoms? Or does the sheer length, complexity, and massive emotional weight of navigating all 25 steps mean that, sometimes, the process itself becomes a heavy punishment, regardless of the final verdict? It's definitely a profound question to consider as you reflect on how justice really operates in our world.